Joining us via Skype from Massachusetts, and Senator Neil Breslin, who's the insurance chair and co-sponsor of the law. I want to thank you both for joining me tonight. Susan, I'd like to start with you, just to get a little bit of context. Tell us your personal story, how this came about with Ian.
The way this came about was Ian was covered by a small group insurance policy that provided home nursing care that became essential when Ian suffered respiratory arrest due to a rare form of muscular dystrophy called spinal muscular atrophy in 1991. And since that time, Ian's survival literally depended on the benefits of the small group policy, and the policy was in place and covered the care that he needed, which did keep him alive, and up to this point has assured his safety being cared for at home rather than in a facility outside of the house.
Now, when you first heard the news that the Guardian Insurance Company was going to drop that piece of the coverage from your son's plan, what was your immediate reaction? What steps did you go through?
Our immediate reaction was first, of course, to contact our insurance company and see if there was another plan or another type of plan that would provide the kind of care that was required in Ian's case, which was the home nursing benefit. And that is when we discovered that our plan was being canceled and there really were no other options being offered currently to the small group market, in other words, to small businesses, and that's what our insurance policy was, that included the home nursing benefit that Ian needed. So, of course, that was the first step in trying to access other options to provide what was imminently going to be lost, and that was the one benefit that Ian relied on to survive.
Right. In many of the things that I've read, it described this really as insurance that he needs to survive. It's coverage that costs about $1 million a year, and it's coverage that he really needs to live day to day. How did you go about making sure that you're going to keep this coverage for your son?
Well, all we could do was go through the process of exploring and researching every insurance policy and type of plan that would be available to small groups. As I said, Ian was covered by a small group or small business plan through my husband's company, and that is when we learned that there were no small group plans or policies still being sold when our insurance plan was scheduled to be discontinued. And we realized that we really had no option in the small group insurance market that we had relied on for decades at that point.
And now I understand you took the Guardian Insurance Group through the court system. You ended up settling with them. I know there's a confidentiality requirement there, so you can't go into too much detail. But that's where I want to bring in Senator Neil Breslin, who heard about this case and then decided in New York State we needed action. Senator, can you describe how you came into this whole case?
Well, I came into it. Eric Schneiderman, Senator Eric Schneiderman from New York City, and I discussed this and how we would handle it and whether there was a hole in the law. And you know, health insurance is to make sure that when you're sick, you're taken care of. And health maintenance organizations can't just say, well, we're going to take care of you unless you get sick. And so that's a pretty basic rule. But in this case, it was a small insurance company that had certain classes of people. And by canceling a particular class of people, one of the people in that group was Ian, who was costing $1 million a year. Now, that seemed to be an opportunity for companies, health companies, in the event of having those kinds of serious expenses, kind of a backdoor way of canceling a policy.
And this was a loophole that was in the law. Susan, if I can ask you, you really found out about this loophole when you started going through the litigation process.
Absolutely, and that was one of the most astounding aspects of this entire situation. Was not only did we suddenly learn for the first time that this benefit that Ian literally relied on to survive was no longer available to us in the realm of the small group insurance market statewide, but beyond that, we learned about the law itself and the fact that the existing law did not really address in clear language a scenario such as this. In other words, not the cancellation or the retroactive rescission of an individual member per se, but the discontinuance of an entire class of policies that covered specific members that were producing very high claims. That was really the beginning of a very intense and very groundbreaking discovery that there was an omission in the law, and that is exactly what Senator Breslin and Senator Schneiderman realized and took the ball and ran with it in drafting this legislation.
Right, and now, Senator Breslin, when you first started to draft this legislation, there were some really inflammatory remarks that came out during the court case that I'm sure sparked some people to motion. In a memo calling Ian an old dog or a train wreck, things like that must have really helped to kick the ball off, get things moving.
I think from the consumer's point of view, it obviously did, but the company involved is a very good company, and so that was inflammatory at the time. Our job as regulators and legislators is to make sure that if there's a little bit of a hole in the law, that we correct that as quickly as possible to cover a case like Ian.
And now, there are some questions, some concerns about this bill. It is being amended somewhat in the Assembly. There are some discussions going on. It didn't pass unanimously in your House. 8 people opposed it. And some of the concerns were, first of all, the length of the process, how long it's going to take for an insurance company to try and drop a class and then move forward with a different benefit.
Right. Well, it's a murky area because an insurance company, they're a company that's in business to make money if it's a profit company, and not-for-profits that do as well as they can. Generally, the big health maintenance organizations have these enormous classes that they would never drop. It's the littler companies that would have the opportunity to kind of play games with this, and if they had someone, one like Ian, or two, someone else coupling with it, to drop that class. So this law is designated Ian's law, is to say, in the case of dropping someone in that situation, you have to give the notice process. And there's a notice process, 90-day notice process, and it's covered by the Department of Insurance, the Superintendent of Insurance, and then an additional 90 days to wrap it up and make decisions. It may be too long, but you have to be very careful that you identify that there's really been a very open and notorious attempt to get around the law.
And now, Susan, bringing you back into this with the timing, it was very important for Ian to get that notification process because without the services he was receiving, I mean, again, you said it was life and death.
Absolutely. The notification process was very important and very essential. But beyond that, what we found or what we believed was missing from existing law was not merely a notification or the procedural process, which the Department of Insurance correctly identified as what was established by statute by the insurance code. What we discovered, though, was that there was no review, no real review as far as the basis or the motivation for an insurance plan, the class of policies itself to be canceled. And that, of course, raised the question of whether there should be a law that actually would distinguish between a legitimate plan cancellation or cancellation of a class of policies